Assalamualaikum and a very good evening. XYZ Sedang Berhad, a private limited company in Malaysia, has called for an extraordinary general meeting (EGM) to seek approval for a significant change in the company's constitution. But that the company is facing resistance from some shareholders during the EGM.
The court says they need to analyse based on the situation about the legal requirement for convening an EGM, the rules of members' resolution, and the rights of dissenting shareholders under the Companies Act 2016.
XYZ Sedang Berhad, a private limited company in Malaysia, has convened an extraordinary general meeting (EGM) to approve the significant change to the company's constitution. However, the proposal is facing resistance from certain shareholders during the meeting. This situation raises several important issues under Malaysian company law. First, what are the legal requirements and procedures for convening an EGM, particularly if the boards fail to act? Second, what is the legal significance of members' resolution, especially for changes to the constitution? Third, what rights do dissenting shareholders have if they disagree with the resolution passed at the EGM? And how are these rights protected under the Companies Act 2016? To analyze this scenario, it is necessary to examine the statutory provision on EGMs and shareholders' rights, consider relevant legal commentary, and explore how these principles apply in practice to protect both the majority and the minority interests in the company.
Next, the legal requirements of convening an EGM. The convening of an extraordinary general meeting in Malaysia is governed by Section 310 to 313 of the Companies Act 2016. According to Section 310, directors may call an EGM at any time when they consider it necessary. However, Section 311 provides that members holding at least 10% of the voting right can requisition a meeting. If the boards fail to act within 21 days of receiving the requisition, Section 313 allows the requisitioning members to convene the meeting themselves within a 3-month window. This provision empowers shareholders to take action when the board refuses to do so, safeguarding participatory rights in corporate governance. Although the Act is silent on cost recovery, legal analysis suggests that the court may order reimbursement if the directors unreasonably refuse to act on a valid requisition, compelling shareholders to incur the cost themselves. This discretionary relief serves to prevent directors from using procedural silence to suppress shareholders' involvement.
Next, the roles of members' resolutions. Members' resolutions serve as the legal mechanism for enacting shareholders' collective decisions. The Companies Act 2016 recognizes two primary forms of resolutions: ordinary and special. An ordinary resolution requires a simple majority, while a special resolution needs at least 75% of approval. Under Section 36 of the Act, any amendment to the company's constitution must be passed through a special resolution. Once such a resolution is lawfully passed during an EGM, it becomes binding on all shareholders regardless of whether they supported or opposed it. This ensures that corporate decisions reflected majority consensus, but also emphasize the need for procedural integrity. The EGM provides a platform for open discussion, debate, and formal voting, thus forming the democratic core of the internal corporate governance.
Next, the rights of dissenting shareholders under the Companies Act 2016. Despite the principle of majority rule, Malaysian companies law also offers protection to minority or dissenting shareholders. Section 346, subsection 1 of the Companies Act 2016 allows any shareholder who believe that the company's affairs are being conducted in a manner oppressive or prejudicial to their right to apply to the court for relief. The remedies under Section 346, subsection 2 are broad and may include orders to regulate the company's future conduct, restrain oppressive action, require the purchase of the aggrieved shareholders' share at fair value or any other equitable remedy the court deems fit. The statutory protection is especially important in cases involving constitutional amendment that may disproportionately benefit majority shareholders or alter minority rights. This legal safeguard prevents misuse of majority power and reinforce fairness in corporate operation.
Next, we move on to the application. In applying these legal principles to the situation of XYZ Sedan Berhad, it is first necessary to consider whether the EGM was convened in accordance to the section 310 to 313. If the directors properly initiate the meeting, procedural requirements such as proper notice and quorum must have been satisfied. If, however, the board failed to respond to a valid requisition by shareholders holding at least 10% of the voting rights, those shareholders has the legal authority to convene the EGM themselves under Section 313. If costs were incurred in doing so, court may permit recovery if the director's refusal to act was unreasonable. Since the EGM's purpose was to amend the company's constitution, a special resolution with at least 75% approval was required under Section 36. Once passed, the resolution binds all members including those who opposed it. However, if dissenting shareholders feel that the changes was made in bad faith or that it unfairly prejudiced their rights, they are still entitled to seek relief under Section 346. If the court finds that the amendment constituted oppressive conduct, it may order the company to buy out the dissenting shareholders, restrain the resolution's implementation, or impose other remedies. This ensures that shareholders' democracy is exercised responsibly without allowing majority interests to override fairness.
In conclusion, the scenario involving XYZ Sedan Berhad illustrates the application of core principles in Malaysian company law that aim to balance effective corporate governance with the protection of shareholder rights. If the EGM was lawfully convened and the special resolution passed with the required majority under the Companies Act 2016, the constitutional change would be valid and enforceable. However, if dissenting shareholders can demonstrate that the amendment is oppressive or prejudicial, they may invoke Section 346 to seek court intervention. In such a case, the court could order remedies such as share buyouts, reversal of the resolution, or regulation of the company's future conduct to protect the affected shareholders. Conversely, if no oppressive intent or impact is found, the resolution would stand and the company would be entitled to proceed with the change. This outcome reflects the Companies Act dual purpose, enabling efficient corporate decision through majority rule, while upholding fairness through judicial protection of minority interests. The case of XYZ Sedan Berhad, though hypothetical, highlight how the law ensures corporate power is exercised with both authority and accountability.